Got it. Oh, good. Good morning. My name is Paul Angerhofer. I'm from the Office of General Counsel here on campus, one of the attorneys here. I've been asked this morning to speak about the topic, the specific gotchas, copyright gotchas to avoid when using media or other electronic sources in the classroom. And let me apologize on the front end. I've got a lot of information, and so I'll kind of be rattling through this quickly. So buckle up your seatbelts and hold on tight. So. Let me start, first of all, with a disclaimer, right? What lawyer couldn't start with a disclaimer? But what I'm going to cover today is just some general information. I'm not giving any specific legal advice. If you have questions, I would invite you to either contact me or to contact the Copyright Licensing Office here on campus. We have a terrific office. Carl Johnson, Susie Corte, and their staff, they're set up to answer specific copyright questions about usages of materials in the classroom. Let me start off by laying somewhat of a foundation, and these are some of the general gotchas that you need to be aware of with respect to copyright law, and specifically these come up all the time in an academic setting. First of all, the myth about the amount. Well, if I'm just using a small amount, it's not going to hurt anyone, right? It's not a violation. That's not always true. A little amount can get you in big trouble. So just be aware of that. The second one here, I purchased a book, I purchased the CD or DVD, therefore I can use it at will however I'd like. Not always true. It depends, obviously, if you purchased it, that's something you can use for your personal use, but that does not always translate into an academic setting or a public setting. The third one, I innocently infringed. I wasn't aware of what I was doing. That doesn't always matter. Ignorance is not an excuse. Ignorance is not a license or a defense in this instance. So that doesn't always translate as well. Okay, the next one. We're a nonprofit, right? We're an educational institution. Therefore, whatever we do, we can do at will. We don't have to worry about copyright law. Not true. The fact that we're an educational institution does not give us a license to break the law. Number 5, there wasn't a notice on the material that I used, therefore it must not be protected. This is an old notion that for some reason continues to linger. Since the late 80s, I think it was 1989, the law has changed. And so you no longer need a copyright notice on a piece of work in order for it to be protected by copyright. So regardless of whether that notice is there, it is and may be protected. Number 6, if I give credit, that's all I need to do, right? Well, attribution is not permission. And this is a concept that's commonly confused, especially in an academic setting, with the concept of plagiarism. A lot of academics in our academic careers were trained about proper attribution and so forth. The fact that we give proper attribution does not translate into permission. And number 7 here, because I'm going to alter the work, I don't need to go back to the original creator. Not true. In fact, one of the 6 enumerated rights that a copyright owner owns is the right to control what is called derivative works. When you create a new work or alter the existing work, that's called the derivative work, and that is something you need specific permission for. Number 8, the work comes from outside the United States. Therefore, U.S. laws don't apply. Well, we've got treaties in place, and we've had treaties in place for over a century now, so that's not true either. Next one, I'm not charging. There's no cash register. No money is exchanging hands. Therefore, there's no copyright violation. Not true. It doesn't. That's not a. It may factor in to an analysis on damages, but it's not a factor that gives you a license to automatically use the work. And finally, number 10, I found it on the internet. Therefore, I must be able to use it, right? Not true again. As we know, the internet, it may be the Wild West there, but there are still laws there. And in fact, this is one area that you really need to be cautious about, because there are what are called copyright trolls, and this is a kind of a cottage industry that's risen in the last 5 to 10 years, and where individuals put images and other content on the internet specifically for the purpose of hoping that you will grab that piece, that photo, that image, whatever, and incorporate it into your own website, with the intent that, knowing that once you do that, then they will come back with some kind of a cease and desist letter and usually a demand for monetary damages. So anyway, just beware of that. Okay, let me transition here and talk just a little bit about what the law does allow us to do. And I'm not going to talk about fair use. Fair use is a concept within the law, but there are 2 areas that specifically address classroom settings. The first one is 110.1, and this addresses the situation where a faculty member, an instructor, can bring into a classroom any material and perform and display it, so long as that material is lawfully obtained and it is in the course of face-to-face teaching activities. So in other words, if I have a CD or a DVD, if I want to bring it to class and display it or perform it, I am allowed to do that. What it does not address is for me to copy that. So if I want to digitize it, or if I want to make it part of a digital presentation, I have just made a copy. The law does not address that. That's where we get to the second part, and this is 110.2. And this is what's called the TEACH Act, and this is about a little over 10 years old. It started off with great hopes, excuse me, this law did. But as things moved along, Congress, it quickly narrowed down very tightly to basically address distance education only. And so there's a lot of disappointment in this because there were hopes that that this law would address the digital classroom, right, and the things, the way education occurs today. But really what it's tailored towards is really a formal distance education. Nevertheless, there are a lot of principles within this section of the code which apply in a classroom setting, in a digital classroom setting, which we think can translate into your classroom presentations using digital technology. And this brings me to the real gotchas here, the specific ones. The code is very specific about things you can and can't do. And there are some things here that you need to be very careful about because they are, in essence, tripwires that are embedded in the law. And if you cross them, you will very likely invalidate your claim of using Section 110.2. The first one here, avoid non-student access. So if you're going to do something like that, where you're going to create a digital source and you're going to allow your class to access, make sure that it is by authenticated access only to those students who are currently enrolled in the course. The next one, avoid the use of commercial works. If you've got, if there's something out there, and when I say commercial, these are works specifically which were developed for the purpose of distance education. And so there are lots of companies out there and universities as well who are creating their own digital content for the express purpose of online course delivery. If you grab something like that and want to pull it into a digital classroom setting, that's one of the big no-nos. The next one, avoid unlawful copies. This was mentioned earlier, but again, you have to have a lawful copy to start with. And so if your cousin Guido comes up to you and says, hey, I got a deal for you, I found this on the streets in New York or something, be wary of that. Okay. The next point, and this last point and the points on the next slide are related, and they're related to a concept that faculty instructors need to understand, and that is, if you're going to do something like this, make sure that there is a clear nexus between the material that you are digitizing and presenting in a classroom setting to the pedagogical purposes. And what I mean by that is avoid entertainment types of things, passive background or optional reading. And these other issues that come up here, avoid works that are not actually part of the class instruction, and only use amounts that are comparable to the amount and duration of what would be displayed in the performance of an actual physical classroom setting. So in other words, I had this come up a few years ago where a faculty member said, oh yeah, I want to use the digital technologies in essence to create my own e-reserves. And so I wanted to download, and this faculty member wanted to download 126 textbooks for this particular class. And obviously there's a huge disconnect there because you cannot use this as a substitute for having the students purchase the material lawfully. And you cannot use it, again, to create your own digital, your e-reserve and whatnot. So be careful about the amounts and make sure they're tailored very tightly and closely to what is being presented in an actual class session. Okay, the next area is beware of anti-circumvention devices. Most CDs and DVDs on the front end will have some type of encryption device or other device that prevents it from being copied. If you disable those devices, that's an automatic violation of the code. So you have to be careful about that. There are some very narrow instances when you are allowed to disable them, but they only apply in film study classes and a couple of other very narrow areas. Avoid downstream copying by enrolled students. And if you've got, and so the intent is if you're going to have your stuff available digitally, The student should be able to access it and access it only for the purposes of that class session. They shouldn't be able to make their own personal copies from it so that they could use and retain at will. As well as it's related to the next point, the material should only be available for a period of time which is coextensive with the duration of the course. So in other words, if they're downloading materials or having access to the materials, that access should cease when that course is over. And finally, the law requires that you put some type of notice, post some type of notice, so that the students are aware that the materials may be protected by copyright and that they need to respect those copyright laws. Thank you.